that hearing before Judge Kollar-Kottelly, like the Rhode Island one, was available online. Many of these hearings have been available online. That's how we're going, right? And that is not normal procedure for day-to-day operations of the federal judiciary. And I take that as another positive sign that these judges are aware that the moment is dire and people need maximal access to what's going on.
Welcome to Law and Chaos. The Trump administration is getting sued in all the courts because it keeps breaking all the laws. I've said it before, and I am sure I will say it again, but boy, do we have a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm really good, Liz. I am excited about today's show. We are trying to piece together what our role, what everyone's role looks like in this brave new world of ours.
Yeah. And look, it's a lot. We definitely feel like, the dog in the tennis ball machine gif all the time. Look, today we're not going to have docket alerts or we're going to have all docket alerts. That depends on your perspective. If you love docket alerts, then that's going to be the whole show. And if you hate docket alerts, we're not doing docket alerts today. We're skipping right to, listen, man, Trump breaks everything. We're just trying to keep up with it all.
Yeah. By now, it's clear to everyone that Trump's plan is to flood the zone with just uncountable shit and hope that we all get overwhelmed and give up and normalize it. And we're not going to do that. So Trump is doing a million illegal things at once and kind of daring everyone to stop him. And I have to say, right, today's show is about how all of us, but in particular, the judiciary and actors before it are not letting him get away with it.
Yeah, I agree. But before we get to that, I read an interesting piece this morning by Josh Marshall at Talking Points Memo. It was called The Three-Headed Chimera of Trumpian Destruction. I put a gift link in the show notes.
It's in the Monster Manual Revised Edition.
It wasn't about the legal system, but it did kind of help me think through the ways that the legal challenges to the Trump cases are going. So just bear with me for a second. Basically, Marshall divides Trump world into three buckets. One is the straight MAGA bucket. They're the Trump devotees. They're the people who've arrayed themselves around Trump as the center of power. That's like Pam Bondi, our newly sworn in attorney general, who is enacting a fatwa at the DOJ against anyone who dared to prosecute Donald Trump. Emile Beauvais, one of Trump's personal lawyers, wants to fire the thousands of law enforcement agents who participated in the January 6th prosecutions and investigations. These two are basically nihilists. They care about nothing. The second bucket is the Doge Bros. They're the ones who sort of fancy themselves part of a class of Silicon Valley Ubermenschen. They think they're smarter than everyone, particularly dumb bureaucrats. I mean, maybe they hate trans people. Maybe they read too much pseudo-intellectual claptrap. They're often wildly chauvinistic while claiming to believe in merit only. Look, their heroes are Musk and Mark Andreessen, the venture capitalists. They want to cut all regulation, and they think if you just kind of let them put the government on the blockchain or whatever stupid crypto shit they're into this week, it will all be better.
Yeah. Did you see that the plan from Doge now is to turn Medicare and Medicaid investigations, as well as proposed cuts to the Department of Education, over to freaking AI, right?
Yeah, these guys are clowns, but I mean, not to say they're not dangerous, which they definitely are, but not as dangerous as the guys in the third bucket. Those are the true believers. They're the Christo-fascists who want to forcibly rearrange American society by co-opting state and federal governments to kind of do their will. And they are fucking dangerous. They are clearly the most dangerous of all. That's Russ Vought, the newly confirmed chair of the Office of Management and Budget, and all the Project 2025 guys. They're in it to ban homosexuality and police speech and make it impossible to get divorced and enforce Christian nationalism, ban abortion, institutionalize trans people, or whatever, all of that. And those are the guys who are really disciplined, right? They hit the ground running this time, and they have not stopped. They're the ones who are punching us in the throat with this deluge of illegal shit every day. But these three factions do not work in tandem. In fact, they often work at cross purposes to each other.
Yeah, I'm not sure that I would divvy up the buckets in the same way, right? But I think the underlying premise that there is not a uniformity of actors in Trump world is correct, right? And I would divide them up into yes, no, maybe on the question of, are you smart enough to keep your mouth shut when a lie would keep you in court, right? So
Yeah.
classic case that we've seen this week in the impoundment cases, Trump's press secretary, Caroline Leavitt, put out that tweet that basically said, look, I know OMB said it was rescinding the impoundment memorandum, but we're only doing that to moot standing and defeat the injunctions where the executive order is still in effect, right? So don't worry about it. And that tweet of hers wound up being cited in multiple orders in the impoundment cases as evidence that the cases were definitely not moot, right? And so, Leavitt is from what you would call the MAGA bucket and I would call the stupid bucket, right? So, well, what happened was people were asking on Twitter, has Trump caved? And she had to run out into traffic and defend Trump's honor and say, he did not back down. It's those liberal, right? And that cost them in court because the DOJ was trying to argue the opposite.
Yeah, well played, Caroline.
Right. And the Doge Bros aren't a big help in that department either, right? Because, Elon Musk is ungovernable. Suppose you're Russ Vought. You're, as you said, the recently confirmed director of Office of Management and Budget. And your dream, right? The thing you have worked your whole life for is to steal the power of the purse from Congress so that the president can collect everyone's tax dollars from the states and then refuse to disperse them for stuff they don't like, right? Unless the states enact his preferred policies. So, if California wants to let trans women pee in peace, well, no education dollars for you. If Illinois won't hand over immigrants to be sent to the gulag, hope you don't want any federal highway funds. Maryland wants to allow abortions, cool, but no Medicaid dollars for you, right? And now you have your hands. They're a centimeter from the brass ring, right? You've got a pliant dipshit in the White House. You have a totally supine Congress in both chambers. And you even have a Supreme Court that has told you they'll pretty much do whatever you're good for, right? All you have to do is play it cool, be really deliberate, make your bad arguments in court with a straight face. You'll lose, but eventually you'll get up to SCOTUS. And there, your win rate is going to go up drastically. Okay, right? Roberts may vote against you in a token case or two. You might lose Amy Coney Barrett if you drool all over you. But you're this close.
And then you have Elon Musk out there on Twitter every goddamn day, just Leroy Jenkinsing it up, right? That jackwagon is constantly announcing all the illegal shit that you, Russ Vought, are trying to do on the lowdown. And he's taking credit for it, he must, right? Which makes it a whole lot harder for you to go to the court and tell a federal judge that what you're doing is on the up and up. You've done all of this through the normal bureaucratic processes. You're doing it in good faith. And Musk's minions are so convinced that they know better than anyone else that they are constantly, flagrantly violating the law and forcing you to lie about it in court, which is not going to help you when you're trying to get to the Supreme Court with, in the best case you can, in the hopes that they will, as they did in the immunity case, let you do the crazy unconstitutional shit you've been planning your whole life.
Yeah. And I think that dynamic, however you divide up the buckets, is key to understanding what happened in a bunch of courts this week, which, by the way, a series of L's for the Trump administration, right? This simmering tension between what we can all see is taking place, right? And what the Department of Justice is trying to defend in multiple lawsuits. So, right, the thing I think underlying what these DOJ lawyers are doing when they argue in court, and you and I have attended audio of a bunch of hearings, right? And we're going to actually talk about that, right? What underlies the DOJ's mindset is something called the presumption of regularity. That is a 13th century Saxony doctrine. In Latin, it is omnia presumuntur right et solemnitur esse acta danac probator in contrarium. And it means all acts are presumed to be rightly done unless proven otherwise. And This principle, the presumption of regularity, has been formally endorsed by the Supreme Court for at least a century, right? And in application, it works like this. It means that when you as a plaintiff challenge a government action or make a claim that the state acted with improper motive, the court will presume that the government acted properly and with the appropriate motivation, absent clear evidence to the contrary, right? And it also means that the court will presume that the government is telling the truth when it makes a representation to it, right? And left unstated is the opposite, right? This is also tacitly understood by anyone who's ever litigated against a government agency. That is, if I, a lowly civilian lawyer, represent to the court that something is false, and the government represents that it's true, the court is probably going to accord a lot more weight to the government statement than to mine.
Yeah, and that's one of the ways that the stolen documents case was bizarro world, because Judge Eileen Cannon treated the government like everything the special counsel said was presumptively a lie. And you may think the presumption of regularity is bullshit. I mean, that's a good argument, fine. But the fact that she reversed it was very notable.
I agree. Here's the thing. The presumption of regularity throughout history has been much more descriptive than prescriptive, right? Like, so the last time that the doctrine was really briefed in any kind of substantive way before the Supreme Court was in Trump v. Hawaii. That was the case challenging Trump's Muslim ban, right? And so the plaintiff said, look, here is a shit ton of evidence in the record that of the president coming out on television, on Twitter, everywhere, and saying, I'm passing the executive order to discriminate against the Muslims, right? Like, and the government, in its briefs, argued presumption of regularity in response. They were like, yeah, okay. Trump said he was going to shut down the country to Muslims and, coming in until, and this is exact language, we figure out what's going on, right? But we dummied up this State Department memo that said we investigated how to stop terrorism, and it was to ban entry by nationals from these 7 countries that just so happened to be majority Muslim. And the courts said, good enough for us, right? And then when it got to the Supreme Court, the Trump v. Hawaii opinion, which again affirmed the Muslim ban, it does not so much as mention the phrase presumption of regularity. Not in the holding, not in the concurrences, not in the dissents, nowhere. And none of those opinions cite to the principal case, right? The one, which is a 1926 decision called United States versus Chemical Foundation, Inc. The presumption of regularity is just so baked into the legal system that it doesn't get mentioned.
Right. But the presumption of regularity was functionally the entire basis for the legal arguments in the Trump first term, right? Trump would announce his intent to do something wildly discriminatory or illegal. He would do the discriminatory illegal thing. And the Supreme Court would say, well, you can't look at his tweets. And the Justice Department says it was a rational policy made without discriminatory or illegal intent. So we have to take them at their word. The only time that did not work was when Trump tried to add a citizenship question to the census as a means of ensuring an undercount in the blue states. Because look, if you ask undocumented people about their citizenship, they tend not to, answer the census at all. Or if they have family members who are undocumented, they tend to omit them from the count. And that means that places like New York appear in the census to have fewer residents than they actually have for the purposes of congressional apportionment. And to be clear, congressional apportionment is based on the total number of persons present in the state, not the total number of right. And that's something that's going to come too, but that's going to be low priority. Anyway, the Trump administration argued that was the furthest thing from their mind. It never occurred to them that they might be gerrymandering the census by adding this question, like, how could you suggest such a thing? And the court was pretty much going to buy it, except after the case was argued, it was basically a leak of documents proving that the Trump administration and the Commerce Department had lied, which shamed Chief Justice Roberts enough that he switched sides, basically, and called out the Commerce Department, which runs the census, for trying to pass off pretextual, contrived justifications for this blatant power grab. That was in 2019 when Breyer and Ginsburg were still there and the court was split 5-4. And so when Chief Justice Roberts flipped, that's what it flipped. But it was one of the few times that the Supreme Court found that the government's presumption of regularity had been overcome.
Right. And that was the landscape for Trump's first term. But I think we're entering a period of unique lawlessness by the second Trump administration, right? And I think the courts are not unaware of this. I mean, look, they read the news. We hear them referring to that in these hearings. Yeah. They saw that Pam Bondi came in as Attorney General and put out a memo saying she was going to target anyone who ever prosecuted Trump, even state prosecutors, and make regular reports on this to the president. And then she said that lawyers refusing to put their names on a bogus filing were going to be fired for insubordination because, real quote, it undermines the constitutional order and deprives the president of the benefit of his lawyers.
Well, that's funny. I thought they were our lawyers.
Yeah, Loretta Lynch on the tarmac. Anyway, look, Bondi is very clearly saying that the purpose of the Department of Justice is not to prosecute criminals, which it is. I mean, look, she shut down the team that was responsible for going after foreign oligarchs. She said that the Department of Justice operates as the president's lawyer. She used the phrase, his lawyers. I mean, ever since Nixon, there was supposed to be a firewall between the White House and the Department of Justice. And Pam Bondi has come out and just said that's no longer a thing. And I think that will have consequences, right? Donald Trump spent the last 4 years accusing the Biden administration of coordinating with New York Attorney General Letitia James and Fulton County District Attorney Fonnie Willis and Jack Smith to bring him down. And part of the reason that all of Trump's malicious prosecution arguments fell apart was because there was this presumption of regularity that applied to the Biden administration.
Well, and also because they were bullshit. I mean, like, not to belabor the point, but his proof was that there was a blind quote attributed to one of Biden's advisors that said he wished that, Attorney General Garland would move a little faster. And the actual argument made by Trump's lawyers, the ones who are now in charge of the Justice Department, was that was a secret signal to Merrick Garland.
Right.
And that meant it was malicious prosecution.
Yeah, hidden code bad, overt direction fine. I mean, look, again, Attorney General Bondi has formally announced that she's going after Trump's enemies. And I think when it comes to courts, she may not get that presumption of regularity at all. But, okay, let's talk about the specific Trump cases and the losses he took this week. Or, well, actually, let's first take an ad break, and then we'll talk about this absolute avalanche of litigation. Unless, of course, you are a subscriber at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, at which point you will never get an ad break. And we're back. Okay, we have talked at a high level about the impoundment clause cases and Press Secretary Caroline Leavitt's dingbat tweet. But as we said, one of those impoundment clause cases was brought by a coalition of nonprofits in D.C. That is the temporary restraining order that was entered by Judge Lauren Alican in the case called National Council of Nonprofits v. Office of Management and Budget, OMB. That is set for briefing this week and next on the motion to convert the temporary restraining order that she has entered into a preliminary injunction that presumably will last until the conclusion of trial, right? So TRO expires after 14 days. Judge Alican has given pretty strong indication that she thinks that the impoundment executive order issued by Trump violates the Appropriations Clause of the Constitution and the Impoundment Control Act. So I think we know where it's going from the court side, right? But apropos of the presumption of regularity and the way that Trump is eroding it, one of the reasons that temporary restraining order was granted was that the organizations continued to be denied their funding even after the government rescinded that original OMB memo, right? In fact, there is ample reporting that nonprofits are still being denied reimbursements even after Judge Alican's order went into effect, which, certainly erodes the presumption of regularity and makes it less likely that the judge is going to take the Trump administration at its word.
Yeah, and that issue is very much a factor in the second impoundment case we're following. That's the one filed by a coalition of states. It's in Rhode Island federal court. So we watched a Zoom hearing this morning in front of Judge John McConnell, who already issued a TRO in this case on January 31st.
Yeah, thanks, Caroline.
Yeah. So the parties are preparing to brief the case on the motion to convert the TRO to a PI, just like you said. And there was some kind of foolishness with the government saying it was illegal to have a TRO that lasted for longer than 14 days.
Yeah, this was an internal email spat over the wording of Judge McConnell's temporary restraining order, right, which said that it was indefinite. But the reason it said that it was indefinite is because oral arguments on the preliminary injunction are scheduled for 9 days from now, right? And so under the Federal Rules of Civil Procedure, a TRO runs out after 14 days. It can be extended by another 14 days, but it is fixed in length. And so, there was mouth noises that the Justice Department was going to say that this is an indefinite TRO, and it wasn't. But as it turns out, right, that never got past an internal email between the DOJ lawyers and the attorney for the state of New York as plaintiff, Rabia Mukadam. I suspect they knew better than to try and make that argument in open court because it's crazy, right? And in any event, Judge McConnell put out a minute order clarifying that the temporary restraining order will only stay in place until the preliminary injunction motion is decided.
Right. But the second issue flagged by Mukadam, the lawyer from New York, the lead lawyer arguing this case for the Coalition of the States, was that the Justice Department has taken the position in communications between counsel that the court order, that the TRO does not apply to funds allocated by Congress under the Infrastructure Act and the Inflation Reduction Act, presumably because those two laws are mentioned in the executive order, which, again, the Justice Department's lawyer, Daniel Schwei, did not make that argument in front of the judge.
well, look, what's he going to say? Hey, Judge, just want to flag a couple ways that I'm blatantly defying your order. Right? Now, let's be clear here. The president cannot override an act of Congress. Two acts, right? The Infrastructure Act, the Inflation Reduction Act, via executive order. Trump is trying to excise out of existence laws that were passed by Congress and signed into law by President Biden. And that's a schoolhouse rock, not a thing. OMB cannot simply continue to impound the money and claim to be abiding by Judge McConnell's order.
Yeah. So look, obviously we have not seen those comments. We don't know. That was a communication between counsel. The judge said basically, well, that is a big deal. And unlike the other issue of the TRO, I'm not going to be able to deal with that in a minute order. Mm-hmm. And Mukadam said she would include it in her brief, that to be filed this Friday, which is today as this show drops. So watch this space, because if Schwei that's the lawyer for the DOJ, was actually stupid enough to say in an email, we're not going to pay attention to the parts that violate the Infrastructure Act and the, Inflation Reduction Act, that message will 100% appear as an exhibit to the motion as another reason that there's no presumption of regularity. And Judge McConnell will not be impressed.
Yeah, I think that is what we would call in the practice of law highly irregular. And look, going back to your overarching thesis, this is not what disciplined evil forces like Russ Vought are aiming for here, right? They're trying to do a bunch of crazy shit really fast, but again, their ultimate goal is to get to the Supreme Court to bless their radical rewriting of the law. So, right, they're not trying to get the trial judge to make a lot of adverse factual findings. They're fine with losing at the trial court because, they want to make new law, but they don't intend to screw it up with a repeat of what happened with the census. Although, I guess, counterpoint to myself, Vought did say all of this in advance when he, authored the Project 2025 manifesto.
Right. And again, Elon Musk is out there tweeting that he and Doge vaporized federal funds in this facially discriminatory manner against protected classes of people in violation of the First Amendment, which is, not super helpful.
Yeah. So therein lies the rub. Okay. Those are the impoundment cases. Next up is a case called Alliance for Retired Americans versus Bessent. That is the Department of Treasury case. We have talked about this a lot, both on the air and in print, because this is a big deal and a huge potential vulnerability that Trump would like to exploit. So this is about Doge's efforts to break into the Bureau of the Fiscal Service, or BFS, which is the department within the Treasury Department that cuts checks on behalf of the government, right? And by that, we mean over 1 billion checks a year worth nearly $7 trillion. It is 90% of all of the payments coming into or going out of the government. And, the muskrats thought it would be swell if they just, got inside and started nixing checks to anyone they don't like.
Yes. And look, we've, as you said, we've written about this a lot, and there's a lot of confusion. Here's the latest reporting from CNN, and I will link to it in the show notes. It says 4 days after Donald Trump's inauguration, Elon Musk's top lieutenants at the Treasury Department asked its acting secretary, a career civil servant, to immediately shut off all USAID payments using the department's own ultra-sensitive payment processing system. The ask was so out of line with how Treasury normally operates, it prompted a skeptical reply from David Lebrick, then serving as acting Treasury secretary, who said he did not believe we have the legal authority to stop an authorized payment certified by an agency, according to a source familiar with the exchange. Lebrick suggested a legally less risky approach would be for the State Department, which oversees USAID, to rescind the payments itself and examine whether they complied with President Donald Trump's Inauguration Day executive order freezing foreign development aid. Tom Krause, a former tech executive and now the top DOJ staffer at Treasury, responded that Lebrick could have legal risk himself should he choose not to comply.
And immediately thereafter, Lebrick was pushed out.
Right.
And speaking of Krause, CNN calls him a former tech executive. And by that, they mean as of 10 days ago, right? Krause is now threatening to put a career civil servant in jail. He, like a lot of these folks, has been hired on as a special government employee. And he has no experience with the law, right? He's the CEO of the company that owns Citrix. But, he's sure that he can pull the strings and cook up a prosecution if the need arises.
Right. It so reminds me of Donald Trump's conversation with Brad Raffensperger, the Secretary of State for Georgia, when he said, if you don't do this fraudulent thing that I'm asking you to do, you are going to be in criminal legal jeopardy. It's so wildly inappropriate. But to be clear, this is another impoundment issue like we've talked about. Trump and his allies want to withhold payments authorized by Congress, which is 100% illegal. But the way that they want to do it is by seizing control of the machinery inside BFS. Then they can stop the payments at the source. They can just kind of code it to reject all disbursements to California or whatever crazy shit they like. And Elon Musk is out there basically confirming that that's what he intends to do. Like on Saturday, February 1, Mike Flynn, that Mike Flynn, rage tweeted about how horrible it was that Lutheran Family Services was receiving government grants to provide aid to refugees. And Musk immediately quote tweeted it and said, the DOJ team is rapidly shutting down these illegal payments. I mean, he's taking credit for it. He's saying that they're doing it.
Yeah, and Musk's underlings, right, Krause and his assigned code kid, a 25-year-old named Marco Illes, got access to the payments processing code, which, for reasons we discussed in episode 104, is incredibly fragile and should not be monkeyed with because it risks grinding the entire federal payment system to a halt with disastrous consequences. So Krause, and until today, put a pin in that, Illes, again, were hired as special Treasury employees. So pull that pin. Special employees is a provision in the Code of Federal Regulations that is meant to expedite approval for temps who work on projects, right? Workers defined as those who will be on the job less than 130 days in a calendar year. So because you're bringing them in quickly, they don't have the same level of oversight in the hiring process. They're subject to some, but not all, of the same ethics rules as regular employees. None of these Doge bros could have made it through the ordinary civil service hiring process, right? And not for nothing, neither could Elon Musk, although for very different reasons, right?
And they certainly couldn't have gotten security clearances.
Right, not without a special presidential dispensation, absolutely. So all of these guys are now under the rubric of special employees. And we're saying that multiple times because that's the magic word you want to have your ears ready to prick up whenever a Trump operative says, oh, don't worry, this stuff is only going to employees.
Yeah. So as we said in our written post yesterday.
Ooh, nice plug.
The Alliance for Retired Americans and two labor unions sued Treasury Secretary Scott Bessent in federal court in D.C., alleging violations of the Privacy Act because a massive amount of personal and financial information about more or less every man, woman, and child in the country is on those Treasury servers, including banking information and just a crazy amount of stuff. So this case landed in front of Judge Colleen Kollar-Kottelly in the federal court in D.C. And look, I think we're starting to see a sort of judicial strategy emerge for dealing with the Trump administration because there's been a ton of reporting that Krause and Illes were screwing with the code and or sharing information with people outside Treasury, which would likely constitute, as we said, a Privacy Act violation. But in court, the issue was whether they had read-only privileges with respect to the code or whether they had read-write access, meaning they could, start fiddling with it and screw things up. And the judge basically said, okay, you, Bradley Humphreys, Mr. DOJ lawyer, you warrant to me that these guys have read-only access and are not going to share any information with, say, Elon Musk. And Humphreys, the DOJ lawyer, really tried to duck that. He did not want to answer that question. And then when the court wouldn't let him wriggle away, he said he had to confer with his client.
Right. So the reporting is that Elez did indeed have read-write access, but they changed it to read-only before the hearing so that Humphreys could be, technically correct, but not the best kind of correct. And Judge Kollar-Kottelly backed him into a corner and said, look, you agree to warrant in print that nobody has read-write access to this data, or I'm going to put you through the trouble of a hearing for a temporary restraining order, and then I'm going to write that order that says that. And so, Humphreys and the lawyers for the plaintiffs, for the employees union, entered into a voluntary consent order late last night, and that order says the defendants will not provide access to any payment record or payment system of records maintained by or within the Bureau of the Fiscal Service, except that defendants may provide access to any of the following people. And then it says Kraus, but read only, Elez, but read only, and then this part that the plaintiffs insisted on, any person who is an employee but not a special government employee of the Department of the Treasury and who has a need for the record or system of records in the performance of their duties, which, as far as I can tell, I looked for where the loopholes are, that seems to cabin the sensitive financial data, right, which includes bank routing and account numbers, right?
Right.
A phishing, dream inside the Treasury Department, at least for now. And if they abide by it, that would comply with the Privacy Act of 1974.
Right. I mean, look, honestly, I would not have banked on them complying by it. They've been so squirrely about all of it, except, as you said, pull the pin. This afternoon, Elez resigned after the Wall Street Journal surfaced his old racist tweets. And look, I'm going to work on the assumption that Kraus isn't competent to monkey with the code and, wouldn't have the chops to do it. So I kind of think we're in a slightly safer place, right? Unless they put another Doge goon in there, but then he'll be a special employee. I suppose that they could, put one of their code monkeys in as a full-time Treasury employee, but that's not going to be nearly as easy. So, and if they did it, I suspect that would take about 38 seconds to leak to Wired or Nathan Tankus, who's been reporting on this, at which point they'd be back in front of the court. So with Elez gone, I feel much safer about the code because they don't have anybody in there to screw with it now.
I agree with that 100%. And I want to flag one more thing here, because that hearing before Judge Kollar-Kottelly, like the Rhode Island one, was available online. Many of these hearings have been available online. That's how we're going, right? And that is not normal procedure for day-to-day operations of the federal judiciary. And I take that as another positive sign that these judges are aware that the moment is dire and people need maximal access to what's going on.
Yeah, and while we're flagging stuff, there's a very similar Privacy Act case filed by several labor unions against the Department of Labor. I'll just read you a little bit from it. It says, absent this court's intervention, DOJ will have access to highly sensitive data, including, among many others, medical and benefits information about all federal workers with worker compensation or black lung claims, the identities of vulnerable workers who have sought the department's protection via wage and hour or occupational safety complaints, and investigative and litigation records of the Bureau of Labor Statistics data, crucial to an accurate understanding of the state of our economy. DOJ will also have access to information regarding investigations of Mr. Musk's corporate interests and the sensitive trade secrets information held by the department, including those of the competitors of those corporate interests, which, well, yeah. He shouldn't have that. So the case is scheduled for a hearing on Friday afternoon. I think it's 2:30 Eastern, and it too will be accessible to the public. We will link to the docket in the show notes.
Yep. Okay, so that's the lawsuit against the Department of Labor. Let's take another quick ad break, and we will be back to talk about the case involving Doge minions coming in and plugging in an outside server at the Office of Personnel Management. And we will be right back after we pay some bills. And we're back. Okay, let's talk about Doe versus Office of Personnel Management. As we said before the break, this is the case about the server that Elon Musk and Doge are using to spoof an hr@opm.gov email address and then fish for information from government employees for God knows what reason. Like, I don't know.
Yeah, let's unpack that for a little bit. According to multiple whistleblowers who were longstanding staffers at the Office of Personnel Management, within days of Trump assuming office, 2 unknown individuals believed to be Musk employees, quote, literally walked into our building and plugged an email server into our network. Immediately thereafter, 2.3 million government employees received, quote, 2 test emails from the email address hr@opm.gov in an effort to discover their private information. It's believed that those emails emanated from the server Musk installed. The first email, which was sent on January 24, said, "This is a test of a new distribution and response list," and directed employees to reply yes to the message as well as click on an embedded hyperlink. I know everybody's like, your blood's rushing to your ears. No! A second follow-up email again asked employees to reply yes to confirm their email address, quote, regardless of whether you replied to the first test email. That second email also took advantage of the fact that they were spoofing the OPM.gov address and warned, quote, as a reminder, always check the from address to confirm that an email is from a legitimate government account and be careful about clicking on links, even when the email originates from the government. And to be clear, everybody sort of knows that the purpose of this was so that they could push out that fork in the road bullshit email, inviting basically the entire federal workforce to resign based on extremely dubious promises about getting paid to do nothing and watch Netflix in their underwear for 6 or 7 months.
Yeah, which don't take legal advice from a podcast or anything, but we've covered that. Don't do that. Okay. Those emails, like, all they're missing is a plea on behalf of a beleaguered Nigerian prince, right? Like, so look,
send your bank routing information.
Yeah, which they have. So our buddy, Kel McClanahan, national security counselors, got together a proposed class action, like, overnight and sued the Office of Personnel Management. And his argument here is a very narrow procedural one, right? It relates to the E-Government Act of 2002, which is codified in the note to 44 U.S.C. Section 3501. This is, you've really got to be on top of your shit to find this, okay? And it says that when the government collects certain kinds of information that includes contact information, right, whether your address or your email address, it then must, every time it collects it or every time it engages in a new activity to use that data, it must conduct a privacy impact analysis, or PIA.
Right. So the PIA is, they're supposed to consider how much information, how sensitive this information is. Is it identifiable? Can they tell who it is? The risk of harm from unauthorized release of this information, right? They're supposed to think about shit and not just like wander in and, stick a server into the wall and say like, now we're OPM, just hand over your email, which they didn't do. Instead, they just sent out that stupid fork in the road email with the, fake buyout offer. So what the plaintiffs wanted here was a temporary restraining order restoring the status quo ante and essentially taking down the server and stopping Doge from fishing for government emails, at least until they complete the required privacy assessment.
Yeah. So plaintiffs sued on January 27th. And this timeline's going to be important in a minute. That was the day after OPM sent that second phishing email. And first up, as you might be able to tell from the case caption, right, Doe versus OPM, was a motion to proceed pseudonymously. That is, again, the baseline rule, that's Rule 10A of the Federal Rules of Civil Procedure, is that a complaint must identify who the plaintiffs are. And that look like that's not a technical rule, right? Like, it is rooted in the judicial doctrine of a presumption in favor of open proceedings.
Yeah. And we support that rule, right? Like, court proceedings should be open. Otherwise, we couldn't report on these cases. And they should all be online, simultaneously broadcast. So, look, it's not just a boilerplate recitation that there's a compelling public interest in, having access to the stuff and knowing the name of the plaintiffs. But there are cases where litigants can and should fear retaliation or have other reasons not to disclose their identities in public, like where they could be fired or, say the owner of Twitter could call down troll storms to ruin their lives, which is a thing that he does like multiple times a week.
Right. And so the way in which that gets worked out in the courts is that presumptions, right, the presumption that you have to name the plaintiff here, can be overcome, but the burden of proof is on the party seeking to overcome that presumption, right, on the litigant. So here, the D.C. Circuit's case law establishes that the party moving to proceed pseudonymously, quote, bears the weighty burden of both demonstrating a concrete need for such secrecy and identifying the consequences that would likely befall it if forced to proceed in its own name. So that's a high burden to overcome the presumption. So counsel entered an affidavit that said his clients were concerned about being targeted for retaliation if their participation in the case were to be discovered. And then paragraph 5 of that affidavit says, given the recent news regarding the steps that the incoming administration has taken to fire or otherwise push out career employees who do not appear sufficiently loyal, plaintiffs have a very tangible and reasonable fear of workplace retaliation.
And relevantly to our discussion about the presumption of regularity, Kel won, right?
Yeah.
Like that motion to proceed pseudonymously, Chief Judge Boasberg on February 4th explicitly cited the declaration and said that although these allegations regarding the danger of retaliation are not set out in great detail, they are not wholly conclusory. And therefore, they met the weighty burden to overcome the presumption of publicity and proceed under the pseudonyms Jane Doe 1 and 2. So that same day, Does 1 and 2 moved for a temporary restraining order with a hearing scheduled the next day, February 5th at 11 a.m. And at 10 a.m. on February 5th, OPM ran the exact same playbook that the OMB ran in the impoundment case, which is that they dummied up a privacy assessment an hour before the TRO hearing. That kind of... I mean, look, they dummied up something, right? It's shaped like a privacy impact assessment, but mostly it just says, like, don't worry, we've mitigated all the potential risks of storing millions of government emails indefinitely on a single source running by Elon Musk. But then they said, look, we did a privacy impact assessment, so that moots the request for the TRO, right? And, well, let's talk about that in 1 second. We're going to pay some bills. We will be right back.
And we're back. So that TRO hearing got postponed by 1 day to today as we're recording this. And Judge Randolph Moss of the District Court of the District of Columbia denied the TRO on the grounds that the relief specifically requested, that is, do the PIA, was now moot because they did do the PIA, however inadequate it was. But we learned some really interesting things during that hearing. So first, I don't know how this factors into the legal analysis, but hilariously, Judge Moss himself got the phishing email. And so at the outset of the hearing, he, to avoid a potential conflict of interest, he had to say on the record, I received the email and I disclaim any potential membership in the class of plaintiffs.
Yeah, you know what? I just read this. It wasn't just Judge Moss. Like a whole bunch of judges got this email that was like, "Are you a federal employee? Like, check yes or no." You know, so it just doesn't show. Like, I'm sorry about that privacy impact assessment, but like, you don't even know who you sent it to.
Right? Yeah. Like, you're gonna have. Would you like to take an early retirement from your lifetime appointment to the federal bench? Right? Like, how crazy is that? Okay. The second thing Judge Moss did was permitted the plaintiffs to go back and amend their complaint and refile that motion for a TRO rather than say, hey, what we want is a privacy assessment, that we want a real privacy assessment, right? To allege that the PIA that was cooked up in an hour before the hearing was insufficient. And over the objections of the government's lawyer who wanted to proceed, quote, in an orderly fashion, not on an emergency basis, Judge Moss set an emergency briefing schedule, right? So that this will all be fully briefed and heard a week from Friday.
Yeah, I mean, so the government's lawyer, Elizabeth Shapiro, didn't just say she wanted to proceed in an orderly fashion. She said, we're dealing with a bunch of TRO requests right now, which, I mean, that's kind of chutzpah. Like, yes, you know why you're in court all the time? It's because you're doing all this illegal shit. And your job is to represent this administration. And, you know, that's what you're going to get.
You're going to be in court a lot.
Right. So Judge Moss started out his questioning of Shapiro in the exact same way that Judge Kollar-Kottelly did with Humphreys in the Treasury case. He said, for the record, that there hasn't been much in the way of transparency, and said, I'm not sure I know the facts terribly well. And Shapiro was like, well, I understand that only OPM employees are working on this email system, which did not slip past Judge Moss. He said, well, that's in the present tense. But what about in the past tense? Who did work on this system? And, he's plainly trying to get at the media reports that Doge sent in 2 goons to plug in the server and that they weren't part of OPM at all. And Shapiro sort of conceded the point. She said that special government employees are bound by all of the obligations that government employees are bound by, which is not entirely true, and is clearly an admission that the Doge Bros were involved in this caper.
Yeah. So in addition to keeping the case on an emergency posture, I was particularly impressed at this point by how invested Judge Moss was in the facts, right? Like, and the law. Like, he got the email. He mentioned at one point during the hearing that he had read all of the privacy assessment cases before the hearing, which, okay, to be fair, there's only like 4 of them, but still, right? I often appear in front of federal judges who have not done any independent research, and I don't expect that. No lawyer expects that, right? They're tragically overworked. And then there was this moment, right? Because as we said, as a procedural matter, Judge Moss felt that he had to deny the TRO. And so Counsel Kell requested an administrative stay instead. He was like, give me at least an administrative stay of a day. And he cited to a case called U.S. v. Texas that was a concurrence at the Supreme Court penned by Justice Amy Coney Barrett. And Judge Moss interrupted him and said, oh, yeah, I see you've read Judge Ali Khan's temporary restraining order in the impoundment case. And okay, that was funny. But what it means is that Judge Moss had read the temporary restraining order Judge Ali Khan entered in that case, right? It means that he's heavily invested. These judges are not just sitting back, like waiting for stuff to happen. And okay, the last thing that I want to highlight from the hearing was when Judge Moss expressed sympathy for the everyday government employees who are sort of caught up in this nonstop legal frenzy, right? Like what he said was, government employees are not responsible for this chaos. And, like I tend to think of all of these as bad actors, like serving as Trump's imperial stormtroopers, right? They're just uniformly carrying out his lawless demands. But, it's not exactly true. And more importantly, depending on the level of truth, it's not how the courts are going to see it. And in particular, right, this is another hurdle that judges are going to have to get over as they are holding the actual bad actors responsible. It's this, I don't want to unfairly burden people who are just trying to do their jobs, and it's all kind of part of the presumption of regularity of judges trying to figure out how they respond to a government that is plainly acting in bad faith.
Yeah, I'm gonna take the under on that one. Like, I understand what you're saying, that it's rough to be a DOJ line attorney in this situation. But I'm going to say that all of these cases that keep these DOJ lawyers tied up in court every day on these stupid ass motions are a part of the way that we must resist and slow this shit down in any. So yeah, I overwork the shit out of them. I'm sorry. You want to work for the DOJ. I understand you need your job. And if this is your job and somebody's got to do it, fine. But I'm going to root for the guys who are taking up as much of their time as possible. I think that's a mitzvah.
Yeah. To be clear, I'm not talking about the lawyers defending Trump at any level, even the 5th lawyer at the bottom of the brief. I'm talking about, and I think Judge Moss was talking about, the civil servants, right? The mid-level managers at OPM.
Yeah, no. I mean, first of all those guys are going to be fired and be replaced with terrible people. And second of all, no, fine. It's the less time they have to spend doing evil shit and the more time they have to spend doing this, fine by me. But let me just observe one more thing, which is that I don't think it's been Judge Moss's regular practice to have hearings online. Like we said, I don't think it's been Judge Kollar-Kottelly's practice either. And I am interested to see if Judge Ali Khan follows suit next week. She hasn't done that before, although Look, to be fair, Judge Moss and Judge Kollar-Kottelly in D.C. and Judge McConnell in Rhode Island, who also had his hearing online, they are all substantially older. The case we just talked about, the labor case, that's going to be online. That's another senior status, I believe, judge named John Bates. Judge Ali Khan is not older. She's young. She's not white. She probably has children living at home. Like, I can understand her not wanting to expose herself and her courtroom in that way. It's a tough balance, but I do look, you see them, right? Judge Moss is talking about Judge Ali Khan's order. They are all doing this sort of not in lockstep, but they're certainly working together.
They're not treating these as unrelated cases. They are looking for the pattern across them. I agree 100%.
Okay. Just a couple more updates on cases we are following. The FBI Agents Association and several of its members have sued the Justice Department to prevent Pam Bondi and Emile Beauvais and the rest of these terrible people from doxing the agents who participated in the January 6 investigations, particularly since Trump freed all those violent criminals and told them that, you can get away with doing terrible things to law enforcement as long as it's law enforcement I don't like. And again, as we said, the judges are starting to hunt in packs, as it were. So Judge Gia Cobb, also in D.C., got the FBI to say on the record that they had not disclosed the list to anyone outside the DOJ, just like Judge Kollar-Kottelly did. And Judge Cobb issued an administrative stay, citing to the same concurrence by Justice Barrett that Judge Ali Khan did. And Judge Cobb put the hearing on the phone access line so we could listen to it. That the second part of the hearing will be today. That's Friday at 11 a.m. We will link to the docket in the show notes, of course. And finally, the Justice Department sued the state of Illinois and Governor J.B. Pritzker and the city of Chicago and Cook County over, for a lack of a better term, sanctuary city laws. That's a kind of a broad rubric that they like to kind of throw around. But to be precise, in this case, what they want is to invalidate several state and local laws that bar local law enforcement officials from cooperating with federal immigration detainers or detaining people on immigration violations for the purpose of handing them over to the feds.
Yeah. And again, to be clear, this is a judicial doctrine that is not at all ambiguous. It is called the anti-commandeering doctrine. And in a 1997 case called Prince v. United States, in an opinion authored by Antonin Scalia, noted liberal squish, right? In that case, the Supreme Court articulated the doctrine, and there, right, it went against us, as you might imagine, Scalia opinion. There, the court said that the federal Brady bill could not effectively force state law enforcement officers to run background checks on people who bought guns in those states, right? And so here's what Scalia said. The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers to administer or enforce a federal regulatory program. It matters not whether policymaking is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. States get to run their own law enforcement.
Wait, but what if you call it obstruction of justice not to cooperate with the feds or a violation of the supremacy clause? Can it be illegal then?
Oh, good Lord. Let me just read you guys one choice excerpt from the section entitled, and I hope you can hear the all caps, Count 2, Violation of the Supremacy Clause, Unlawful Discrimination Against the Federal Government. Defendants' enforcement of the challenge provisions discriminates against the federal government. The challenge provisions single out federal immigration officials expressly and implicitly for unfavorable and uncooperative treatment when other law enforcement officials are not so treated. Accordingly, the challenge provisions violate the doctrine of intergovernmental immunity and therefore alternatively are invalid on that basis. And no, it does not. The doctrine of intergovernmental immunity says that the feds can't do the states' jobs and vice versa. That is part of the supremacy clause. The states aren't enacting their own immigration laws. They're refusing to expend resources to enforce federal immigration law, which they are absolutely 100% approved by Antonin Scalia entitled to do. This case is embarrassingly bad, right? And frankly speaking, it gives you a pretty good idea why Attorney General Pam Bondi has to threaten attorneys to make sure that they put their name on Justice Department filings, because I sure as hell wouldn't. This is gobbledygook.
Oh, you're not convinced by this amazing argument? They say By refusing to honor civil detainers and warrants expressly authorized by Congress, defendants have unlawfully eliminated these means for federal immigrations. Yeah, they wrote immigrations officials to carry out their statutory functions. No,
and the federal government is now a protected class magically. Yeah, it's amazing.
Yeah. So, look, the DOJ tried to designate this case as related to another civil suit, which was filed by immigrants' rights groups suing the Trump administration to challenge the executive orders that he passed, the anti-immigrant executive orders. That challenge is on a First Amendment grounds. That case is in front of Judge John Ness, who is a Trump appointee. But this case, the Trump case, landed on the docket of Judge Lindsey Jenkins, a Biden appointee, who scheduled a hearing on this dumb turkey in April, which, no, you can't combine a First Amendment case and a Supremacy Clause case or whatever the hell this case is. I don't even understand what this case is about, but it's definitely not about the First Amendment, and they're not getting combined.
Yeah.
So, okay, that is going to do it for us today. Stick around for the subscriber bonus, where we will talk about the birthright citizenship litigation with a special appearance by the gun humpers of America. Spoiler alert, they're again it. Okay, we'll see you guys. Have a nice weekend.
Law and Chaos Podcast is a production of Raise Ipsum Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsum Media, LLC, all rights reserved.